Thank you. And welcome everybody. Good afternoon or good morning, depending on which coast you're on or which segment of the country you're on. We welcome you to this webinar. My name is Kathy Ruckelshaus, and I'm General Counsel and Program Director at the National Employment Law Project. Today you have three presenters on the call. In addition to me, you have Michael Hancock, who was 20 years at the U.S. Department of Labor, primarily in the Wage and Hour Division, and his last appointment there was as Assistant Administrator for Policy at the U.S. Department of Labor. So he's an expert on implementing the white-collar and other overtime law and assisting employers in compliance with all kinds of wage and hour laws at the federal level. So he'll be a very excellent presenter for all of us. The last speaker is Ann Babcock-Steiner, and she is Senior Vice President for Human Resources at the Pathstone Corporation, where she's been since 2006. She's also an attorney, and she has a lot of experience complying with overtime rules under existing rules, but also she is an expert on the new rules. So you're in good hands. Before we get started, I just wanted to give you a couple of housekeeping tips. We are going to have a question and answer period at the end of our presentations. And if you see on the box on the side of your webinar, there's a place to ask questions. And you can log in questions anytime during the presentations, and we'll take them either during our presentations or likely at the end at the half-hour time segment that we've left for questions. The PowerPoint slides that you're seeing on your screen are going to be made available to everybody, so you'll be able to get them in a downloadable fashion and click on links and anything else that any other resources you'd like to have. And we will also provide you with additional backup research and fact sheets and written resources that we've pulled together for you at the end of the presentation. So welcome again, and we're going to get started. So I'm just going to give you a little bit of background on the rules and the context for the rules. These rules, in our opinion, are good for everybody. The rules now, starting December 1st, mean that anyone with a salary who makes less than $47,476 a year has to be paid for any overtime hours. And overtime is over 40 in a week. So this is a bright line rule that Mike will talk a lot more about, but that's the main change in the rules. And the Department of Labor estimates that these changes will entitle 4.2 million white-collar employees to overtime. Economic Policy Institute estimates an additional 8 million on top of the Department of Labor's estimate who are likely entitled to overtime now but haven't been receiving it. So they will finally start getting the pay that they deserve. So that means that more than 12 million workers will either see more money in their pockets or have more free time for themselves and their families as employers spread the work around. Where employers do reassign work hours rather than pay time and a half for the overtime hours, part-time workers who want more hours will get more hours, and those who are unemployed can apply for jobs that will be created by the redistribution of the work. And this is all part of the policy behind overtime. And lots of nonprofits, like people on this call, have lined up in favor of the rules. There are obviously some exceptions, but many nonprofits submitted formal comments to the Department of Labor's rule expressing support. And then a recent letter signed by about 150 nonprofits was sent to Congress to support the rules. And the letter accurately made the point that while some nonprofits have to think through and solve some institutional changes, that the nonprofits signing the letter supported the goals of the new rules. And these goals are improving the economic security of the people whom the nonprofits serve, and also supporting the economic security of their employees. And just a little bit of history, this new Bright Line rule brings the overtime coverage back to where it was supposed to be. When the white-collar exemptions were initially put into the law, they were intended to cover and did cover about half of all salaried workers, and that was this was at least in 1975. Half of all salaried workers were covered by overtime, and the act is meant to cover those most workers, and so this exemption for the so-called white-collar workers are really only supposed to carve out those with sufficient independence in their jobs about how and when they can do them. But because the rules haven't been updated meaningfully in 3 decades, now hourly workers and salary workers making less than $23,660 a year qualify for overtime pay. So in 2014, that was only 10% of salaried workers who were automatically covered by overtime, whereas in 1975, half of all salaried workers were automatically covered by overtime. So under these new rules, much more of the workforce will be automatically covered by these protections. And most Americans are in favor of these rules. NELP's Action Fund recently polled likely voters in 7 states, and the positive responses were incredibly strong, with percentages ranging from 81% to 76% of the polled voters who were in favor. And a Gallup poll in June of this year found that 76% agreed that more workers should be getting overtime protections. And a lot of states already provide these protections. The 16 states that are listed on the slide are ones that tie the overtime exemptions to federal law. So that means starting in December, when the federal rules go into effect, these 16 states will also have their state laws covered by the federal. Other states don't have any white-collar exemptions, or they have exemptions that are different from the federal laws. So you should be sure to check your state laws if you haven't already. And the Department of Labor has extensive employer compliance materials on its website, including very specific materials for nonprofits. And we all urge you to look at those materials. They're very user-friendly, and they have FAQs and excellent questions and responses. And we can talk about this more in the question and answer, but the National Council of Nonprofits is currently working with the U.S. Department of Labor and the White House to see whether or not there can be some reopening of some federal grants that you all may be receiving to seek additional monies to cover any costs that you might incur when you comply with these new rules. So I'm going to turn it over now to Mike Hancock, who's going to do his section of the presentation. Mike? Do we have Mike?
Can you hear me?
Now we can, yes.
Okay, all right. Sorry about that. Thank you, Kathy, and thanks everyone for joining this webinar. This touches on 2 issues that are near and dear to my heart. One, FLSA and the protections they afford to workers in the U.S., but also nonprofits. Decades ago, I come from that world. So I have a sense and an understanding of what you're dealing with in managing programs that are, under the best of circumstances, often cash-starved. And now you're looking at perhaps another obligation. So I'm not unsympathetic, but I have to say that I fully support what the administration has done on the overtime regulation. It really wasn't in my estimation, a very difficult call for them. The regulation as it existed before this change had a woefully inadequate salary level, and couple that with a greatly reduced burden for proving that the duties apply to employees, really set up a situation in which very low-paid workers were being classified as overtime exempt. And the consequence was, in many instances, that these workers were actually working at an hourly rate below the minimum wage. And I don't think anybody would contend that that's the purpose of the overtime exception. So I think they did a very good thing when they enacted these new regulations. My presentation really is going to cover the overtime issues, but in order to do that, I think effectively we have to get into some other issues, both as a predicate and then some of the other issues that are likely to arise as you're dealing with these new regs. There are some FLSA basics that people need to be aware of. There is a question of coverage for nonprofit employees that's unique to the nonprofit world, and it goes to the basic question about whether or not you're covered by the FLSA at all. And if the answer to that is no, then you not only don't have an obligation to comply with overtime, but you're not covered by the FLSA more broadly. The next section is going to deal with how non-exempt employees must be paid. I know that there are a number of people who, in adjusting to these new obligations, are considering making heretofore exempt salaried employees into non-exempt employees, and we'll talk a little bit about how to do that so that you don't run afoul of other FLSA principles. And then finally, there's the question of calculating compensable hours worked and regular rates of pay, important considerations when you're dealing with non-exempt employees. So let me just dive into this. There are some things that everybody needs to keep in mind as sort of predicates for everything that's going to go on as you consider these. One, the sort of fundamental premise underlying the FLSA is that all covered employees must be paid at least the federal minimum wage for each hour worked. And secondly, that all covered employees must be paid time and a half the regular rate of pay, which oftentimes is higher than the minimum wage in any work week in which they work over 40. That's sort of the bedrock principles underlying the Fair Labor Standards Act. And it's helpful to remember that in its original conception, overtime was thought to be a penalty imposed against employers who chose to work their employees more than 40 hours in the work week. It was intended to encourage them to spread employment, to hire additional workers if they're going to exceed 40 in a work week, and if they chose not to hire additional workers, to make them pay this what we come to think of as a premium, but in its original conception was a penalty. And the third principle that I think everybody has to bear in mind is that any employer claiming an exemption has the burden to prove that the exemption applies. And those who've litigated in this area fully understand that there's sort of this rule of thumb that coverage is broadly applied and exemptions are narrowly construed. So if you're going to take advantage of an exemption such as the overtime exemption, you have to fit within the four corners of that. Now, the first question that every employer, but it's particularly true of nonprofits, I think, has to ask is, am I covered at all by the FLSA? Employers, including nonprofits, may be covered under this law in one or both of these ways. One, enterprise coverage. Enterprise coverage looks at the enterprise as a whole and asks a basic question about whether their business generates more than $500,000 in annual revenue. It's called enterprise coverage. And even if the enterprise doesn't reach that $500,000 threshold, individual employees in that enterprise can be covered under what is commonly called individual employee coverage. And that looks at the extent to which individual employees are engaged in interstate commerce. And we'll talk a little more about that later. And then as Kathy indicated, and this is sort of one of those mantras that you're going to hear, even if you answer those questions under the FLSA, you have to realize that state law may be different, and there's no preemption, so you have to comply with both the FLSA and state law when it comes to these sorts of issues. So here, I hope in a nutshell, are the FLSA coverage of nonprofit principles. As you'll see, a nonprofit with gross revenues over $500,000, and it's not just any kind of revenues, it's commercial activity and not donations, are covered under the FLSA. In addition to that, there are certain specifically named sorts of establishments, and they're listed there, that notwithstanding the $500,000 threshold, these establishments are covered by operation of law. So if you're a hospital, a school for the disabled or gifted children, preschool, secondary schools, they are by operation of law covered without regard to their annual revenue levels. As I indicated, individual employees engaged in interstate commerce are covered, and here are some illustrations of the kinds of things that they may do that would bring them within that coverage. There are many others, but really the question to ask is, do I have employees who are crossing state lines in pursuit of our business activity? And if the answer is yes, then they are going to be covered as individually covered, even if the enterprise isn't. Now, here's the question that I think everybody here is interested in. How will the new overtime rules apply to nonprofits? Once you get through the coverage determination, and if you determine that either the enterprise or individuals within the enterprise are covered by the FLSA, then you get to the question of whether or not you can claim the overtime exemption. In order to do that, you have to meet three basic tests. One, the primary duty of of an employee who you're claiming the exemption for meets the duties test. And the regulations, which are unchanged from the 2005 changes, that primary duty test still must be met. The second question is the salary basis, and we'll talk about the salary basis in a minute, but that basically means that they're paid at least the minimum salary required every work week without reduction. There are some exceptions to that without reduction, but broadly speaking, they have to receive that $913 every work week without any reduction in pay, aside from the normal sort of deductions for taxes, insurance, et cetera. And then finally, the salary threshold, and this is what changed in the most recent iteration of the regulations, where they raised it from $455 to $913. And there's another, and this has been in the reg since 2005 as well, there's a category of employees called highly compensated employees. Until December, they have to be paid at least $100,000 a year. In December, it's going to go up to $134,000, and we'll talk a little bit about that, although I don't think this is the area where most people are focused. So again, here are the changes. It raised the salary threshold to $913 per week, which is the equivalent of $47,476 a year. And if they fall under that, they have to be paid overtime. The rule is effective December 1, 2016. It will be adjusted every 3 years, beginning in 2020, and it will be pegged to the same methodology that was used to determine the increase to the $47,000 and change in this regulation. So you can expect every 3 years the Department of Labor will publish a new salary level that has to be met in order to claim the exemption. And then, as Kathy indicated, there's a small group of group homes for the developmentally disabled who will receive an enforcement delay until March of 2019. Now, I hasten to add, this is a discretionary act on the part of the Wage and Hour Division not to enforce in those instances, but that does not affect the right for individual employees or groups of employees employed by those organizations to bring private litigation. I'm not saying it's going to happen, or that it's a certainty, but a enforcement delay is different than a regulatory change that would not make it effective as to these entities until that date. I'm sure you've all seen this, but I'd be remiss if I didn't bring it to your attention. The department, the Wage and Hour Division, issued in May of 2006 what I think is very, very good guidance, specifically directed at nonprofits on the effect of the reg and how to comply. So if you haven't, or if you haven't read it recently, I would highly recommend that to you. You can also, if you need a more sort of personalized set of compliance assistance, you can always contact your local Wage and Hour Division office. They have many, many around the country, and you can ask them to give you some compliance assistance, and they're always happy to do that. So again, all covered employees must receive the overtime unless they're exempt, and I'm sure you know this, but the overtime, this overtime exemption is not the only exemption that may apply. There are other overtime exemptions. I'm not going to go into those, but there's a whole array of other ways that people might be exempt if you're interested in exploring that further. And you'll find that at the Wage and Hour Division's website. They have to receive overtime for every hour over 40, and it must be 1.5 times the regular rate of pay. And I just gave an illustrative way that works. If somebody's straight time pay is $9.88 per hour, they must receive that $9.88 per hour for every hour worked, and then for every hour over 40, they receive an additional $4.94. That's how one calculates, and I know that this is simplistic, but I thought it was useful to illustrate it nonetheless. The other important thing to remember, and this is a place where, in my experience at Wage and Hour, we often found violations, is that an employer doesn't need to explicitly authorize an employee to work overtime in order to be liable for paying that overtime. If the employer knows or has reason or should have known that the worker is working overtime, then you're on the hook for the overtime. So it's important to have very explicit policies in place if you need to manage overtime, and then you have to monitor it and implement it in a way that demonstrates your good faith in making sure that the employers did not work overtime despite the policy. So here are the sort of basics for a exempt salaried employee. They have to meet these three basic conditions, and then there's a proviso at the end that I feel compelled to raise because it comes up all the time. First, their primary duties are defined as exempt, and each of the three categories of exempt employees, executives, administrative, professional, have their own specific definition of what are exempt duties, so you need to pay very close attention to that. They have to be paid at least $913 per week. There are some exclusions from that general rule, and I'll touch on those later. And then that's the salary basis. They have to be paid on a salary basis, which means there can't be any reduction in that $913 unless it meets one of those narrow exclusions. And then this is something that I can't emphasize enough. It comes up all the time. You see it over and over again where both the employer and the employee alike think that if they're paid a salary, they're not entitled to overtime. And that's one of those wives' tales that's out there. People believe it as an article of faith, but that's simply not true. And so I think that people need to be cognizant of that and make sure that that's not happening in your operations. Here's a very brief summary of what constitutes exemptions, exempt duties on the EAP test. I'm not going to go through these. I think most of you understand that. The basic test for executives is that they manage a organization or a department in an organization, and they regularly supervise 2 full-time equivalent employees. Now that can mean they supervise 2 40-hour-a-week employees. It can mean they supervise 4 half-time employees. But at the end of the day, it has to tally up to at least 2 full-time employees. And those it has to be done in such a way so that you don't have 2 claimed exempt employee supervising the same two. That's another common mistake that we've seen, is that, well, I was supervising two, well, so was I. That doesn't count. The administrative exemption, and this is the place where you find the most difficulty and where you find the most violations. It's a very soft test for exemption, and it's one that has been abused in the past and is one that's been subject to a lot of litigation. And so you need to take great care in assessing whether or not your administrative personnel for whom you're claiming the exemption really do fit the test. I think it's probably less true in the nonprofit world, but one of the sort of articles of faith is that the work that they're performing can't be production work. It can't be somebody making widgets on a production line, or it can't be somebody who is producing insurance policies in an insurance company. It has to be something more than that. And then the professional, this is another place where there's a fairly bright line. There's a little softness in how you define work requiring advanced knowledge acquired through a prolonged course of specialized intellectual instruction. But if you can fit squarely in one of the clearly recognized professional categories, then there's not a lot of ambiguity about whether the exemption applies. Now, I need to say that the salary test has some exceptions, and they fall in the professional category. There are certain professions in which there is no minimum salary that has to be paid if they otherwise fit the duties test, and we'll cover those a little bit. Again, this is something we've already talked about. There's the minimum salary in December. There's the adjustment every 3 years. In the professional categories, there's no minimum salary for otherwise exempt teachers, doctors, or lawyers. So those three professions are exempt from any minimum salary. So if they otherwise meet the exemption, the definition of teacher, doctor, or lawyer, then you don't have any obligation to pay the 913 or frankly anything. And then I'm not going to get into the exempt computer professional. They can meet the test one of two ways. They can fit the category of computer professional and be paid the minimum weekly salary, or, and this is something that's much different than the other categories, they can be paid a minimum hourly rate of $27.63. But I hasten to add that these computer professionals, it's a fairly narrow definition of what constitutes a computer professional, and it's really operating at a very high level within that field. And I'll touch on this only briefly, but there were changes made to the highly compensated workers. They must regularly perform at least one exempt duty. They don't have to meet the full duties test, so long as you can demonstrate that they are performing at least one exempt duty. They must be paid, and this is effective in December, $134,000 per year, and then like the regular salary, it will be adjusted every 3 years as well. Now, the salary basis test, this is another place where we've seen through the years that employers lose the exemption. They don't comply with they pay the minimum salary almost routinely, but they do something under the salary basis test that makes them lose the exemption. They must be paid the same weekly salary regardless of how many or how few hours they work. So if you have an exempt employee making the 913 and in 1 week they work 30 hours, they show up at the office every day, but they have to leave early to attend some seminar at 3 o'clock every day. So they're not working their full normal 40 hours a week. You can't reduce their pay. They have to be paid the 913. There are some limited deductions that are permitted without losing the exemption. But again, this is a place where people make mistakes and they lose the exemption as a consequence. I think the important rule of thumb, and this is the place where we've seen through the years most of the violations, has to do with partial day absences, where an employee is, for whatever reason, has to leave early, and that employer chooses to dock their pay for the time that they weren't there, or they seek to use their salary or a reduction in salary as a means to discipline an employee. And both of those will result in you losing the exemption. Now, in preparing for these new regulations, and again, they're effective in December, this is sort of standard advice, but I can't say it often enough. I would recommend that you review all the jobs that you're currently classifying as EAP exempt, and if there's any chance that you will continue them in that exempt status, then you have to do, I think, a thorough review and ensure that the employees are actually doing the duties that meet the exemption. Too often I've seen employers wave around the position description, which was designed in their HR department to clearly meet the exemption, but when you talk to the employee and you talk to the coworkers, it's clear that that employee is not performing those duties. They're performing duties that don't meet the exemption, and so the exemption is denied. If you find that there are position descriptions that don't accurately reflect the duties, it's in your interest to update that PD, either by including those duties that aren't part of the exempt duties, or by reassigning that worker to duties that make it clear that they're within the primary duties test. And then again, you've got to make sure that the salary basis test is met. So these are the things that you're going to have to do after December. You're going to have to pay a weekly salary of at least $913. Again, ensure compliance with any state law. There's no choosing between the two. The higher standard between the FLSA and the state law applies. And then another change, and I don't think it's going to be something that you're going to see commonly in the nonprofit world, but for the first time, it allowed the use of non-discretionary bonuses or incentive pay to count towards the minimum salary threshold. If you're interested in that, there's a lot of good compliance material at the website, at the Wage and Hour website, that will explain how this works. But no more than 10%, and there has to be a reconciliation at the end of a quarter to make sure that for every work week in that quarter they were paid $913, either because they were awarded their non-discretionary bonus or the employer paid makeup pay to bring them up to that $913. Now, here are some cautions as you're looking at, and if you're transitioning from non-exempt or from exempt employees back to exempt non-exempt employees, where counting compensable hours worked becomes absolutely essential and critical because you're going to have to pay overtime for everything over 40. You have to brush up on some basic FLSA principles. First and foremost, what constitutes hours worked? What hours do you have to count towards that worker's compensation and make sure that they're paid for every hour that they work? Generally speaking, once they start the workday, if they come in at 8 o'clock and they power up their computer and their day starts, everything that happens between that point and at the time when they power down that computer at the end of the day is going to count as hours worked, except for things like lunch periods where they're completely relieved and able to enjoy at least a 30-minute lunch period. Everything else counts. If they're taking a 10-minute break at 10 o'clock, if they're taking a 15-minute break at 3 in the afternoon, those still count as hours worked and have to be tracked and paid. Another issue that often comes up, travel time and training time. There are special rules that apply to when travel is compensable hours worked and has to be paid, and you should pay special attention to that if travel is common in the job assignments for your now non-exempt employees. Training time is another place where you often see employers make mistakes. There are special rules that apply to training time, and again, it's in everybody's interest to brush up on those. There's another concept, engaged to wait or waiting to be engaged. I think this is going to be less common in the nonprofit world, but may be present if you have periods in which an employee has downtime, the question becomes, is that time controlled by the employer, or is that time that the employer can use for themselves? And so you'll need to take a close look at that. Finally, there's this thing called a work week. That's the period of time in which you calculate the 40 hours and any overtime that occurs. There's no concept in the FLSA that the work week starts on Monday morning and ends the next Monday morning. It can be any 7-day period. But once you fix that work week, if you try to manipulate the work week to minimize your overtime obligations, that's going to be something that the Wage and Hour Division is going to look askance at, and there are limited circumstances in which you can do that, but you have to be very cautious. And then we already talked about the regular rate of pay. That's the fundamental basis upon which overtime obligations are calculated, and I'm sure you're all familiar with that. Now, here are other resources. There's the Wage and Hour Division has developed a very good overtime page, has a lot of fact sheets, has a lot of Q's and A's. A lot of information is there that will help you as you're sorting through your options. And so I highly recommend it. And I think now I'm going to turn it over to Ann, who will really, in some detail, and talk about some of the options available as you're thinking about the best way for your organization to stay into compliance with these new rules. So Ann, I'm going to turn it over to you.
Okay, thanks, Mike. I just want to check everyone can hear me, or somebody verify that.
I can hear you, Ann.
Okay, good. Thank you. My name is Ann Babcock-Steiner, and as this slide shows, I'm the Senior Vice President of Human Resources for Pathstone Corporation, and I am also a licensed attorney who kind of got tired of doing the standard things that lawyers do and moved into human resources. I'm going to start by giving some background about my employer, and I am doing this not to promote our wonderful organization so much as I am to go over some facts that can give you guys as nonprofits some perspective as to how they impact an organization our size, which is fairly large, and certainly some of the similarities with the issues that you guys may face. And so this is going to set some of the context for some of the strategies that I'm going to be talking about later on. So here we have Pathstone Corporation. Here's our mission. I don't need to read it verbatim. I will just say that historically we started in the 60s serving only farm workers, and we have evolved into many different areas since then. And if you look at the next statement, which is our vision statement, the second bulleted point, really at the back end of that statement is going to be the relevant language I'm going to talk about in a little bit. We help people attain economic and social resources for building better lives. And if I were to sum up what we do in a couple of words, I would say that Pathstone provides direct services to low-wage workers. That becomes relevant to a little bit further down. Actually, I'm going to digress right now and tell the story. So Kathy, talked about the new regulations and talked about some nonprofit support, and that there certainly are some nonprofits who don't think that these rules are very good rules. The proposed are the changes now. And last year, it was right about this time last year, I was responsible for drafting Pathstone's comments on the proposed rules. And our original stance was that these proposed overtime rules were going to make it more difficult and harder to do business. We're on 3-year grants, we're locked into the wages, how are we going to cover these costs? And I had kind of an 11th hour revelation, and as did our board of directors, and said, wait a minute, our mission compels us to support these regulations. We're wearing 2 hats here. We're an employer and we're a service provider. And we also have to consider the needs of to me at least, the most important low-wage workers that we serve, and that's actually our employees. You know, it's not uncommon that nonprofit employees, particularly those in the field, are low-wage employees. So I bring this in just because I'm later going to talk about some of the opportunities and linking things to your mission. Okay, just a little bit more background on Passstone. We have a $65 million operating budget, so we're fairly large. Of that, we're about 95% federally funded. And the irony of all ironies is that an overwhelming majority of our federal funds, our largest federal funder, is the Department of Labor's Employment and Training Administration, because we do a lot of dislocated, displaced worker training programs. We have operations in 7 different states and in Puerto Rico. We're mainly, New York, Pennsylvania, Ohio, Indiana area. And we have 15 lines of business, which I've just kind of given you. They fall in one of 2 categories. That's not all 15, but just to give you an idea of what we do and what we're dealing with. If you were to look over here on the direct services end, that is more likely where a lot of your standard kind of field work, lower wage jobs are going to be. But when we start moving into our community and economic development, that's where we maybe more compete with the private market in some of those jobs, say for example for real estate developers. So this is what we were looking at the time that the regulations came out in March, I think it was. And this was the snapshot of Passstone. We had a total of 589 year-round and seasonal employees. 463 of those 589 employees earned less than the new overtime threshold of $47,476. Now, an overwhelming majority of those 463 people were already classified as non-exempt based on their job duties. But we do have a group of about, and this is always changing, but about 42 employees who have who could qualify for the overtime exemption based on their job duties. But now, because of the increase in the threshold, they're no longer going to qualify for that exemption. So when we look at the impact on Passstone, we're really looking at these 42 people right here. And then we're also looking at this total cost, and this is our annual cost. If we were to raise the salaries of these 42 employees to the threshold. Okay, so the impact on nonprofits. Everybody knows, I mean, there's been a lot of talk that the increase in the salary threshold is going to have a disparate impact on nonprofits. And the reason that we say that is because our jobs tend to pay a little bit lower. And so we often have somebody, there's a disparity. This is a language that I use. There's a disparity between salaries and job duties in nonprofits. So you have somebody who's a program manager and has, they're making management decisions and meeting all of those criteria, and they're being paid a salary, and they supervise 2 people. But that salary that they're being paid for an equivalent job in the private market, maybe they'd be making $50,000, but in the nonprofit world, it's really more like $36,000. So that disparity between job duties and salaries is why you're looking at a bigger impact on nonprofits. Also, we can't raise prices to cover higher labor costs. Many of us, particularly those of us who get state funding or federal funding, we can be locked into 3-year funding contracts. And so we're kind of stuck with what we have unless, we have a way to renegotiate. But it's not all bad news. It really isn't. We do have some opportunities here as nonprofits. And this is the one that I don't think everybody likes to talk about, but they are out there. And for me, I'm speaking just from kind of the past own perspective, and I've spent an entire career working in nonprofits, and so it is other work experience too, that nonprofits tend to be pretty inefficient. And the best I can come up with, my reasonable guess here is nonprofits lack the profit motive of other for-profit companies, right? And so, and with all due respect to some of particularly our governmental funders, they, a lot of their reporting systems and grant requirements might be a little bit antiquated, so that it makes us do duplicative work, and we have to report the same outcomes on multiple systems and things like that. So we tend not to be as efficient as we could be. We tend to underutilize technology, and I mean these are broad generalizations, but we tend to underutilize technology as well. And so I think for this, we're looking at how are we going to get our work done in 40 hours a week, and this is the low-hanging fruit. This is what I keep saying where I work. This is the low-hanging fruit. Let's identify where we're inefficient, and let's address those areas so we can get people to do their work in 40 hours a week. The next opportunity is the work-life balance. And, as I said, nonprofits generally pay lower salaries, and we also generally offer better benefits to offset those lower wages. And, we have, as I said, we've got nearly 600 employees. We do a lot of recruiting, and all of our supervisors, are always saying, well, Pastone has wonderful benefits compared to the private sector. We use our benefits as a recruiting technique. And I'm saying now that we can also use a 40-hour work week to be marketed as a benefit. This is a benefit for some people. I mean, actually for a lot of people it would be a huge benefit. And then finally, the mission. And so one of the things to ask yourself is, will your constituents benefit from the new regulations? And this is where we had our change of heart, and we had said our mission compels us to support these regulations. And ideally, in an ideal world, we work with low-wage workers. In an ideal world, we would work ourselves out of a job. And so maybe we'll be able to serve fewer people. Maybe we'll only be able to serve 80 people on Section 8 instead of 100 because of these new overtime rules. But maybe those 20 people would no longer qualify for Section 8 because they are in turn making more money themselves, because Section 8 is an income-based program. So we're never going to work ourselves out of a job, but at the same time, as we better things for our participants, particularly because we serve low-wage workers, this is very closely related to that. As things get better for our participants, hopefully the demand for our services will go down, and therefore we could maybe reduce some of our workloads. Okay. So there's, I'm going to go over 4 strategies for compliance, and I'll tell you kind of the combinations. I'll tell you my favorite ones. I'll tell you my least favorite ones, and give you guys some things to work with and some tools to utilize. So the first one would be to pay current salaries with overtime. That's basically just saying, okay, well now, these people, these 42 employees are now getting paid overtime. That's kind of pie in the sky. We could raise our salaries to the new threshold, so that if somebody is exempt based on their job duties, you simply raise their salary. Pie in the sky maybe again. Reorganize workloads, adjust schedules, or spread work hours. That's probably my favorite, but we're going to be doing a combination of all of them. and adjust wages downward to reallocate them between straight time and overtime. And that one is my least favorite. And that's actually one that we are actively disavowing at Pathstone. We're not going to do that. Two big questions to ask yourself as you kind of go through this and figure out which strategy you want to deploy. These are the pieces of information that you always need in analyzing each individual employee. You always need to keep in mind, does the employee qualify for the overtime exemption based on their job duties? You know, we can't get kind of lost in just saying, I'm going to raise their salaries and I don't have to pay them overtime. But you still have to satisfy the duty test. And this is your chance to look at all of this comprehensively to make sure that you're fully in compliance. And then you need to know if your employee, in question regularly works more than 40 hours a week. Obviously that's a huge question, but sometimes we lose sight of that. And I've seen this happening where supervisors are analyzing all of this, and should I raise their salary? Should I not? What should I do? And then, they pull the last year of time records, and this person has a 40-hour-a-week job. So, it's not necessarily as big of an issue as I thought. So the first strategy is to just pay overtime. And so that would be somebody who's now eligible for overtime, and you're just going to start paying them overtime. So when would this strategy work? Obviously it works best when the employee rarely or never works more than 40 hours a week. Some of the downfalls are obviously the overtime hours are not predictable. They're not, or they may not be easily predictable. They may not be consistent. For us as a federal grantee, we do have through, I think it's the uniform guidance. I think that's what it's through. We do actually have an obligation to minimize overtime hours. So that could potentially be a problem. We're not prohibited from incurring overtime, but we have an obligation to minimize it. So that would be one of our concerns about this. Okay, so the next strategy would be raise salaries. So this is when you would take somebody, their salary is maybe close to the threshold. They qualify for an exemption based on their job duties, and they routinely work more than 40 hours a week. Now, when I did the initial analysis for our entire corporation, I was really, I was gung-ho that this was going to be where the answer lied for us, because I figured that folks who were making or who had the job duties to qualify for the overtime exemption, that their salaries would be close enough to the $47,000 threshold, that it wouldn't be that big of a deal. And I was very wrong. I was very, very wrong. We had some significant disparities, $10,000 a year. Now certainly we have a few employees that we would just have to raise their salary a couple hundred a year, and that's wonderful. But, we have all sorts of different scenarios that make up that $267,000 price tag. So the downfall, obviously, for raising salaries to the new threshold is where are you going to get the money to cover it? I mean, it's a huge thing for nonprofits. And that could be a non-starter for most people right there. But, on the assumption that you could get the money to do that. The next major downfall is salary compression, and this is, not a compliance thing, but this is certainly more of an employee morale issue. And the salary compression is how you make sure that there's a fair distribution of pay amongst your junior staff and your senior staff, those with more seniority and more experience than those without. This usually comes up more in the context of when minimum wage is raised. Most of us don't have a sense that we make a certain amount above the overtime threshold. But so, for example, if the minimum wage raises from $12 an hour, or say it raises from $10 an hour to $12 an hour, obviously anybody making lower than $12 an hour is going to get an increase. But what about the person who makes $13 an hour, who used to be 20% above the minimum wage threshold, but now is a smaller percentage above the minimum wage threshold. That's what the salary compression is. And so usually you end up adjusting not only the impacted employees' salaries, but you also might have to upwardly adjust salaries and maybe the band that's right above them. It's certainly more art than science. And so it's just something that you would have to look at, like a ranking list of salaries usually helps. So that's something that could come up. The other strategy, and or the other downfall, if you were to just raise strategies, or raise salaries up to the new threshold, it's not a great idea to give pay increases that are not tied to performance. They're kind of given to random employees. Employees might feel slighted. The employees who are getting an increase might feel like I can keep getting increases without necessarily having to do the performance that goes with it, because believe me, as much as you explain over and over and over again why their salary is increasing, they truly may not understand it. So it's generally not a best practice to randomly increase pay, or it could create some morale issues. Okay, so I have a little piece on each one of these about analyzing the strategy. And of course, after I did this, I found an online tool that is really going to allow you guys to do all of this stuff. And so I'm going to go through this really quickly because at the end there's a link to a spreadsheet that ADP has put together that really does all of the behind the scenes math for you. So in order to determine whether or not raising salaries is a good strategy, you would want to review the total number of hours worked for the last year for the relevant employee. You obviously need to calculate the cost of increasing the threshold. You want to calculate the number of hours that could be worked if you were to pay overtime, and then you need to compare number 1 and number 3, because that will really give you an idea, because sometimes if you're only going to pay, maybe if you allowed an employee to be eligible for overtime and that increased your cost, say they only worked 10 hours a year, 10 hours a month overtime, it might be cheaper to pay them overtime for those $10 a month as opposed to raising their salary to the new threshold. And so that's why you want to calculate all of these numbers. And again, I have there's a really great tool that I'm going to share with you guys. Okay, and here is an example of how you would do this. So John makes $20 an hour as a program director. His annual salary is $41,600. He works 45 hours a week on average. If we were to raise his salary to the new threshold, it would cost about $5,800. His OT rate is $30 an hour. And so that bulleted point right here, let me just get this little pointer. This one, this 196 hours, if you see here, what I do is I take this, because that's how much you raise his salary by, and then I divide it by his overtime rate so that you can get this number, okay? And so that kind of gives you a comparison point as to whether or not you should pay overtime or raise the salary. So in this case, raising John's salary makes more sense than actually paying him overtime. And I realize that these examples may be a little bit confusing, but I promise you that they will make a lot of sense when I show you this spreadsheet. Okay, so another strategy is to adjust workloads and work hours. And so when this would work is when raising salaries and or paying overtime are simply not financially feasible. And so here are some options for doing this. Most of our positions have, reporting requirements, or staff need a certain amount of time per week to fill out reports, a certain amount of time per week to maybe do classes, to do baseline core services for our participants. Anything that's a predictable and a routine job duty, you want to front load that so that you're in your work week, so that your discretionary tasks are at the end of the work week, so that you can look and you can say, okay, this employee is now going to be getting overtime, and they did on Monday and Tuesday, Monday they did the reporting, and Tuesday and Wednesday and Thursday they delivered all the services. On Friday we were going to work on maybe a brainstorming session to see about how we could expand services, or maybe we were going to do some cross-training opportunities in other areas. If you put the non-essential job duties and schedule them for the end of the week, then you can presumably adjust those as the week goes on if you're looking at incurring overtime costs. If an employee regularly performs job duties outside of their regular work days, adjust their work hours. So for us, outreach is an example. If they're doing outreach, and for us, they have to do outreach with farm workers. And if the best time to do that is at 6 o'clock in the morning, then you adjust their work day accordingly. So you kind of throw out the concept of 9 to 5 for certain people, and you set their work hours as needed for their particular position. And then you can also, transfer some job duties from full-time staff to part-time staff is another one. Then the final option is to transfer job duties from non-exempt employees to exempt employees. And so this is basically, now you have somebody who is, I should say, transfer job duties from newly non-exempt employees to exempt employees. So you have one employee who you're able to keep them as exempt because either their job duties were okay and they were already above the salary threshold, or maybe it only cost a couple $100s a year. Now you have another employee here, employee number 2, who used to be exempt but is now non-exempt. And so a strategy is to take some of those job duties from the non-exempt person and put them to the exempt employee. Now there's a whole bunch of caveats here. I have been advising our executive staff, our supervisors, to, if you're going to take job duties and move them from that newly non-exempt person and from the non-exempt person to the exempt person, you should try to give the new job duties to the person who just got a salary increase to keep their exemption, right? And then that goes back and addresses the other point that I made, that you don't want to just randomly be giving out raises, but then this would be tied to an increased workload, so switching things around. And then the warning is that, oh yeah, okay, see, she just has me wrap up. I'm almost done. The warning here is to be careful that when you transfer job duties, that you don't jeopardize the exemption status of the employee who's receiving those job duties, okay? And so that you want to make sure that the person who is exempt won't end up getting a bunch of non-exempt job duties and then losing the exemption on that basis. Okay, I'm going to wrap this up super quick. Strategy, this is adjusting wages downward. What it is you can convert your salary into an appropriate hourly rate where the anticipated overtime is built in, and so that annual compensation would remain the same. It's just a reallocation of wages from between basically straight time and overtime. This strategy would only work if employees regularly and consistently work the same number of overtime hours per week. Here's a mathematical example of it, but I'm going to breeze over that because I've got a tool for you. The downside. The downside is that Generally, employees will still view this as a pay cut, or they'll view it as some sort of demotion. Mike talked about this notion of why misunderstanding about salary. There's also some sort of prestige about salary, and if somebody goes from a salaried position to an hourly position, and we've had this happen through we regularly and routinely audit our job descriptions and reconcile our work plans, like Mike was saying, make sure the job description reflects the duties. We do that once a year, and oftentimes people are reclassified out of it. I have at least 5 people a year who have been reclassified from exempt to non-exempt. And they argue it with me over and over and over again because they went to college and they should be salaried and not hourly. And so, and I just blame it all on the government because we're just complying with the law. And then the major downside to this is if the employee doesn't work that anticipated number of overtime hours, their pay actually will decrease. So this adjusting wages downward, this is something that we at Passdown have absolutely decided not to do, and we're not allowing it. So this is the tool. Here's a little quote by an inspirational quote because it's relevant, and this is my quote. And I always say that I went to law school because they told me that there wouldn't be any math. And they lied because there is a little bit of math, and there was even when I was actively practicing. This is a screenshot of a tool that I have a link to at the back, and it's put together by ADP. It's a spreadsheet, and it's going to go through some of the options that I talked with you about, okay? And all you're going to have to do is you're just going to have to fill in a few pieces of information, and it is going to give you all sorts of recommendations accordingly, okay? So then that link is at the end. Okay, things to consider. You can consider using more volunteers. Just be aware of these rules that can come with its own issues with the Fair Labor Standards Act. And then a few questions to consider. Can you cross-train staff so that you can consistently, on a continuous basis, shift job duties around to keep work weeks within 40? Are your staff engaged in activities that are not directly related to your mission that you could cut? And can you be more efficient with your use of technology? And then here are the resources. I think this one here has been given a couple times. I highly recommend that everybody read this from cover to cover because it pretty much answers everything for you. And then this is the calculator that I showed you, and so I also recommend that people use that. So that's all I have.
Thank you, Anne. Can everybody hear me?
Yes.
Okay, good. Well, we're going to move to questions, and thank you so much. I know we have some great questions pending, and we are going to do our best in the 15 or 17 minutes that we have left to answer them, and we're going to collect them in categories so that we try to get them as all of your questions answered. And obviously, because the 3 of us have provided our contact information on the slides, and we're going to be sending you additional materials, we're available for follow-up questions for you. One is somebody asked a question about individual coverage and said that a lot of the materials seem to gloss over how to figure out whether somebody's covered as an individual, even if you're a nonprofit, isn't covered as an enterprise. I mentioned in the beginning that NELT has a specialized memo that collects recent cases on individual coverage, and it gives really good examples of who is covered. But Mike or Anne, would you guys like to give an overview of individual coverage for this question?
Well, Kathy, it's a fairly complicated issue, and I would recommend the NELT publication for those that really want to dig into this. But the rule of thumb is if you have employees who are routinely, as part of their job, engaged in cross-border activity, emails, processing invoices, whatever it may be, then they're likely to be found to be individually covered. What I've seen some enterprises do is concentrate that work among either employees that they don't work over a 4-day work week or employees who are otherwise exempt under the exemption test. And that way you're not going to run into a back wage issue. You may have a lot of people doing a little bit of this, and if you're really concerned that it's going to kick you over into coverage, then I would suggest concentrate it in a way that limits your additional financial wage obligation. And I know that's not realistic for every organization, but many who confronted this have found that they can actually do that fairly effectively by just reorganizing that piece of the work of the organization in a way that minimizes their additional potential wage obligation.
Yeah, and I will send around this memo. It's excellent. And I think with technology and lots of employees using email, especially today, obviously faxing and collecting orders or doing fundraising that crosses state lines is going to put you into individual coverage. But also people who send reports or research out of state via email should be covered. Same with anyone who's sending a quarterly report on the nonprofit's charitable work to a board member out of state. Employees who are involved in making pamphlets, publications, surveys that is sent out of state, again, via email, which is a common way. Fundraising via telephone or out of state, or processing fundraising donations. Those are all examples. So it is pretty broad, and I think if you're, as it is with most of the exemptions under the Act, it's better to be safe than sorry. Okay, another question is, we had the question earlier about the state law, and Mike mentioned twice that state laws and the federal law interact with each other, and the employee is permitted to take the best of both. So you can't ignore either. You have to understand what the rules are under both state law and federal law and comply with the most protective laws, the best laws for the employee. Okay, here's a good one, I think, for Anne, likely. If the nonprofit is going to reclassify an employee from exempt to non-exempt as of December, what needs to be done administratively? Do they just need to issue a new employment letter, or what's the best practice on that?
So obviously whatever your current practice is and what your state law requires, if you have wage notice requirements that require that their exemption status be listed out, that you would do that, then you would do whatever is required internally as well. As far as processing. Some of the other things that we've had to look at is timekeeping policies, timekeeping systems. We actually do not right now have a punch-in, punch-out system. We use a cumulative system, and we're seeing that we need to buy a punch-in, punch-out timekeeping system. You need to look at all of your wage and hour, all of your related, work week and payroll things, policies, to make sure that they're updated, because you have to understand that a lot of people will now be needing to keep track of their time. And Mike talked about this, these travel rules and what is counted as compensable time. You guys are going to need to understand that. My understanding is that it's not uncommon for nonprofits to have most, if not all, of their workforce, classified as exempt, which is probably wrong. But again, this is an opportunity to come into compliance. So you're going to have a lot more people whose time you're going to have to manage. So the final piece is management training and supervisor training. We have been doing training, now on what is a compensable hour, how to manage time. On our new policies, one of our new policies is supervisors are now required to look every single week at timesheets. and to see what time has been logged. Employees have to log their time on a daily basis so that supervisors can look at this, so that we have time to course correct to avoid incurring overtime. So those are just some practical things that you need to worry about too.
Okay, thanks. And we have a really good question that I think any of us could answer that was proposed, that the questioner wants to know our thoughts on a possible solution, which is just to simply ask the employee who regularly does work overtime to just work 40 hours and not work overtime. Is this a realistic request?
No, I don't think so. It's like, who's been listening in on my conversations with my supervisors? No, I mean, it's not right now. I think this is kind of the artistic piece of it, right? This is where you really need to look at this and realize that out of the gate, no, it's not a realistic expectation. We're going to have to find a way to do it, or we're going to have to pay overtime. Personally, I think this is going to require the executives, the leadership team to seriously focus and sharpen missions. Not get sidetracked, really not trying to save the world, but trying to do what you do well and limiting it to that. So I think that it's going to be a gradual transition. I think from a cultural standpoint, from a compliance standpoint, if it's not realistic, then you're going to have to pay them for it, so it's a real.
I mean, it's interesting because there are rules under the Fair Labor Standards Act about record keeping that Mike mentioned earlier.
Mm-hmm.
And so it's on the employer to make sure that all hours worked are compensated, but the employer is permitted to have a no overtime policy. It can say, we don't want you working more than 40 hours in a week. And obviously, as Anne's mentioning, people often can't comply with that, but there is even now increasing case law around, employees' use of BlackBerries. This is outside of the nonprofit context, but or other smartphones where workers are working more hours than the employer wants them to work, but they can't help it because the job requires it. They have to answer email. So there are cases that permit employers to have a policy of no overtime, and then if the worker works overtime and is breaking that policy, they still have to get paid, but the employer is permitted to take disciplinary action against them if they routinely work overtime and they're not supposed to. So I think it's one of those gray areas that it's hard to get compliance, but it could be a way to try to save some money by not having your employees work overtime.
Well, I'm going to have to go back in time and put on my wage and hour hat. This is one of those areas that's fraught with all sorts of dangers. It's not enough to announce a policy that I don't want you to work over 40 in a work week. If that supervisor knows or has reason to suspect that worker is working more than 40 and not recording those hours, you're going to be on the hook for that. So it's not enough to have a policy. You have to have effective follow-up by the supervisor and make certain that they're monitoring that kind of activity. And if they knew or should have known that they were working over 40, you're going to be on the hook for that.
And I think that that's a great strategy training opportunity to teach supervisors and put your own accountability on supervisors for making sure, that one of your supervisors' performance measures is that they are keeping the work within 40 hours a week, but they're also accurately recording the work. And you could make that as a performance measure for your supervisors themselves. One of the things we're thinking about doing very, very initially in the infancy, but we have a lot of outreach workers, people who are constantly in the field and moving around who need cell phones. We allow people to bring their own devices. So these are field level workers that are very clear. Never, these new rules don't change anything. They were always getting overtime. They were always eligible for overtime. there's software systems that cut off their access to company email at a certain time so that they can't access company email on their smartphone at 8 o'clock at night. So there are things out there. These are the things that nonprofit employers tend not to look at because those software systems are expensive, but probably not as expensive as overtime.
Okay, so I have lots of questions, and we're going to try to get through as many as we can. But someone asked the question of how these new rules would impact flex time policies. They have a staff that can use flex time within a work month as opposed to a biweekly pay.
Let me try that one. Overtime obligations are calculated on a work week. So if somebody works 45 hours in work 1 and works 35 hours in week 2 because they took that excess 5 hours off, you still owe 5 hours of overtime unless you're employed by a public agency. You can't use flex time as a way to minimize an overtime obligation that you otherwise owe.
Okay, yeah, that's right, and that's called. There is a lot of guidance on that. Sometimes it's called the flexible work week, and there's guidance on that. So if you'd like to look at more, that Department of Labor's website has good FAQs and guidance on that. So another question, and some of these are pretty basic. We've already answered the individual question, but there's someone who asks about on-call time, and Mike, you mentioned this briefly in your presentation, but there's a staff person who works at this organization. She works over 40 hours during the week, but is also on call over the weekend.
This is a place where there's quite a bit of guidance outside of the overtime area at wage and hour. It's an issue that came up during the home care regulatory implementation phase. So there's some fresh guidance. You're not going to find it necessarily in the overtime context, although I haven't looked that closely. They may have something there. The general rule of thumb on call is if their activities are so restricted that they have to be at a certain place waiting to be called, or they have to report within 10 minutes of getting that call, those sorts of restrictions on their use of their own time during that on-call period will convert that into hours worked. But on the other hand, if they're able to use that time effectively for their own purposes, if they're told, I want you to have your cell with you, if we call you, we're going to give you 2 hours notice that we need you to come in, then they're not going to be, that's not going to be counted as hours worked in the typical case. So it's all about the extent to which that employee's activities are restricted by the on-call policies of the employer. So if you make it loose enough so they can effectively use that time, that's not going to be compensable hours worked.
Okay, so we have time for one more question. We have about 3 more minutes left on the time, and so I'm going to ask the question that someone said that in the Department of Labor guidance for nonprofits, it states that the Department of Labor will focus its enforcement efforts on those who meet the enterprise test. And how do we interpret that?
Well, I'm not going to presume to speak for the Department of Labor, but I think you can take them sort of at face value that their enforcement priorities are not going to be on individual covered employees and nonprofits. It's going to be focused on the broader question about enterprise coverage, nonprofits and for-profit companies. So it doesn't mean that you get a free pass on this, but I think what they're trying to signal is that's not going to be where they're going to be spending their time and resources, is looking at individually covered employees who may or may not fit the exemption.
And I think that's all of our time. We've gotten through most of the questions, but we know there's a few more pending, so we'll be in touch with you individually, and we will be sending out these specific materials that cover much more about individual coverage and other facts. So thank you all very much for participating, and I'll turn it back over to the operator.
Ladies and gentlemen, that does conclude the webinar call for today. We thank you for your participation and ask that you please disconnect your line.